So here we go again about the legality of BDSM and bodily harm. We've covered this a few times, but there's a neat new case out that sort of brings it to the forefront, and I'm going to turn it over to you to sort of frame this.
Well, and this is a recurring topic for me too, because I think it's really important in our society for people to know what they're legally allowed to do and what they aren't.
Right.
And so that gets a little bit sketchy when you get into people. And, you know, there's all different levels of BDSM and stuff. Since 50 Shades of Grey, a lot more people kind of experimenting. And these cases, you know, that we're going to talk about.
It's not relegated, you know, to that dark realm, you know, like.
Yeah. They cover a wide variety of behaviors. Yeah. So we have like a little top 5 things that we're going to talk about, things that you should know about the legality of BDSM and bodily harm. One is you can't get advance consent. And in BDSM, sometimes people talk about having contracts and negotiating stuff about what they want to do and what they don't.
Yeah, in a lot of cases, you'll see that there's a contract between the two parties. They stipulate, you know, all sorts of conditions. Mm-hmm. And, you know, something in writing about providing consent for a specific act, we've covered this, can be relevant to whether consent was provided, communicated consent was provided at the time of the alleged offense, but you cannot obtain through a contract advance consent.
Yeah, consent can be withdrawn at any time.
Correct.
And number 2, you can't consent to bodily harm. And so that gets complicated, and we'll get into that. Number 3, you can't have agreements such as no means yes. And there's a specific case, actually a few results came up.
Yeah.
Where they actually said, well, but no actually was supposed to mean yes. And that is definitely not permissible. Number 4, participants must know who is touching them in order to consent. And so that gets into cases where somebody is, you know, bound and maybe blindfolded and things like that. And we'll cover a few different aspects, you know, in specifics on cases we're going to talk about. And number 5 is that judges will decide what people can or cannot consent to, and judges tend to be a little bit prudish.
They can be, you know. Some of the cases that we've read, some of the more recent cases, I mean, you know, certainly this last one, judge did an entire postscript about Parliament needing to rethink and courts needing to rethink about whether you can consent to bodily harm within the BDSM play scenario. So I'm seeing a bit of a shift.
So that's a really current one. And like you said, like the judge made some comments at the end about discussions that should be had. And we'll get into that. So I think instead of dealing with them point by point, those are the main topics that we want to cover. And let's just go into the case. We can give the citation, R.V. Pearson, 2025, ONSC, which is Ontario Superior Court, and number 435. So that's the case that we're looking at. And you can go find this on canley.org.
Yeah, and Jordan Gold was the defense lawyer on this one. He did a very good job. And both the Crown and defense called expert evidence on BDSM. And there's some interesting evidence, including Jordan's cross-examination of the Crown's expert, which we'll factor into when we talk about the postscript and what may come of it if there's going to be a reconsideration.
Mm-hmm. So there's a whole bunch, and this is getting into a little bit more of the extreme.
Yeah, this is a much more extreme case, yeah.
Yeah, it's, they say right at the very beginning, the first paragraph, caning, flogging, nipple clamping, stapling, choking, slapping. The parties agreed to engage in these BDSM activities as part of their sexual relationship. And then, on one occasion, there was a baseball bat involved, yeah. And not for hitting.
And she testified that she did not consent to the use of that baseball bat.
Right. So did you want to cover the basics?
Let me cover some stuff, because I like the way His Honor has written this. And I think
Carter?
I think it's His Honor, but how the judge has written this. So this case presents issues that are in some ways straightforward and in others more complex. The issue of a complainant's subjective consent to sexual activity arises frequently in these courts and is largely determined by findings with respect to the person's credibility and reliability. Whether the complainant here consented to having the baseball bat placed inside a private area hinges on these findings. Having consent vitiated for public policy reasons is far less common. Can a person consent to being flogged, caned, clamped? There is little guidance in the jurisprudence as to when vitiation should occur in the context of the BDSM world. So this was a very interesting way of framing this, with acknowledgement that, in fact, there's very little jurisprudence to give guidance on this. And up until now, courts have been very clear that there are guardrails about what consenting individuals can do and what you can't consent to.
So should we, at this point, speak a little bit maybe about bodily harm being permitted in things like sporting events?
Sure, if you want. I mean, that all factors literally into the postscript, but we can start with that if you want.
I think up front, just to say, like, because so bodily harm, you can consent to being a boxer and getting into a ring with somebody, and the two people are beating the crap out of each other, and it's a sport and it's legal. And people do get seriously injured sometimes in sports that are really physical like that. And, not just boxing, but even like football and stuff like that. There's people who have serious head injuries from playing football. And, but you're permitted to consent to engaging in sports because there's a public interest in sports.
Yeah. So first of all, let's just define. So bodily harm, you can't consent to bodily harm. And bodily harm is an injury that's more than trifling in nature and transient. And so it's pretty broad definition. And you can have, for example, redness that heals in a couple of days, or some marks that heal in a couple of days, that may or may not constitute bodily harm. Generally, it doesn't. Certainly some things described in here didn't meet the threshold of bodily harm. And the definition of bodily harm, as I said, is something that's more than trifling or transient in nature. But you raise a very good point, which was brought up in the postscript. And let me just frame this for a moment, because
I think it's good to frame it that way.
Both the Crown and defense advanced arguments and called experts regarding a law that should be changed regarding certain BDSM practices, and maybe that it should not fall under a category of activities to which a person cannot consent to bodily harm. The issue is whether the law on consent to bodily harm, as it currently stands, reflects today's social norms, practices, and values, or should be changed to do so. The judge didn't need to decide the matter. This was a postscript, so this is unusual. I would note that the defense has put forward a compelling case that the matter should, at a minimum, be re-examined. And again, that's why I'm saying Jordan did a very good job on this. As the law stands now in Ontario, a person cannot consent to the infliction of bodily harm in the context of a sexual relationship. The standard of bodily harm is not a high one. Bodily harm, as I said earlier, is defined as any hurt or injury to a person that interferes with their health or comfort of the person and is more than merely transient or trifling in nature. I've emphasized the disjunctive nature of the definition, hurt or injury, health or comfort, transient or trifling, to demonstrate the wide spectrum of situations that are potentially captured. It will not be uncommon in BDSM to intentionally leave marks that would meet this definition. This is important. One such scenario was put to the Crown expert, and there was an exchange. I'm not going to read the entire exchange, but they're saying, let's say you have this couple who's been together for a long period of time. They're married, and they engage in some BDSM play, and that involves, let's say, spanking. And it's hard spanking that leaves some red marks that last for 2 or 3 days. The expert was asked, do you believe that this is bodily harm that should come under the context where it's prohibited by law? And the expert said, no, I don't. Let's say that the marks remained for 7 to 8 days. Would you have the same opinion? I would have the same opinion. Especially if there's neither of them who are complaining about it to the police. If both of them were consenting, in other words, correct? Exactly. If both were consenting and not making a complaint because it went too far, or there were other issues, but I think that these are fair examples. If a stable couple consenting activities, and between the two of them in their own bedroom, then it should not be prohibited by criminal law. So that's an interesting thing. So this stuff will go on. It only becomes known if somebody goes to the police and says this happened. But, we can maybe imagine another scenario. But what they're saying is, and when you looked at the expert evidence, approximately 5% of the population engage in BDSM to the point of recognizing and naming it as such. That would equate to 1.9 million Canadians who report engaging in some form of BDSM play. further, there are probably around about 50% of the general population that at least engages in fantasy about BDSM behavior. So it's not relegated to that dark side anymore. And you've made that very good point that, we've had that book and the movies and all that. So there's also noted by one of the experts that there are benefits to this type of play. It's personal growth, self-actualization, connection with your partners. There can be, therapeutic benefits. It's a equally important part of people who are in the LGBTQ plus community. So these are all relevant factors as to a form of sexual interaction that is well recognized and part of our society.
And that plays into the public interest thing, where there's a public interest in allowing people to engage in sports. Is there a public interest in allowing people to engage in intimate behavior in a way that excites them?
Right.
And brings them satisfaction?
Now, back in 1995...
That's going to be the question for Parliament coming up, I think.
Well, but back in 1995, these types of benefits to this type of play was considered by the Court of Appeal in 𝐕 Welch, W-E-L-C-H, 1995, 25 OR 3rd 665. In fact, the court appeared to accept the general proposition that hurting people is wrong, and that if sadism is allowable, if consented to, then it is consent rather than moral conviction, which polices the barrier between a society of would-be sadists and the kind of society most of us would like to inhabit. I'm really not sure that that's applicable anymore. And I think that's a bit of an extreme position in 2025. Yeah. And people in this who enjoy this play don't see it as hurting people and being sadistic necessarily. There's certainly extreme forms of this, but there's a broad spectrum. And so this type of moral reasoning, I don't think is something that is as applicable. And you raised an interesting point. So the judge raised this as well. One wonders why there are much more extreme violence found in mixed martial arts like MMA, which is not sanctioned. In other words, it's not criminal. As the defense pointed out, in MMA, extremely serious injuries are intentionally caused to win a fight. Nose breaks, bones break. It's not a criminal assault if both parties consent to the activity. The vast majority of Canadians surely do not engage in this practice. Presumably, a minority of Canadians have no interest in watching that particular sport. Many, if not, understand how a fan watching such violence can be entertained, but some people derive some value from it. Well, a lot of people do, because it's a multi-million dollar business. And there's various classes now. There's MMA, I forgot. There's many,
and there's like
organizations that have championships. Go ahead.
And there's female MMA
100%
championships and stuff like that.
And boxing.
They're quite impressive. They take it very seriously. This is not just a toxic masculinity kind of sport.
Right, and boxing as well. So, a similar argument could be made about, the value that some people find in participating in or watching MMA type of fights or combat sports, if we put it that way, as you would in BDSM. And these are all very tricky issues that are raised. But the court makes a very interesting point here, that this may need to be looked at again. And then he makes some reference to American model penal codes. But the point is that what the United States has as far as definitions of bodily harm or levels of physical harm may be applicable here. But the conceptual argument then is, if you allow it for these extreme sports, combat sports, which some people derive benefit from and a lot enjoy participating and watching, why are we so, to put, prudish or so morally strict in one way about what can happen between consenting adults in a bedroom? And make no mistake about it, if a person doesn't go to the police, it doesn't come to the police's attention, but they're engaging in conduct. If you inflict bodily harm and both are consenting to it, that's a criminal act under the criminal code, even though nobody runs to the police. And that's why I said, do you really want, the state that much into your bedroom?
Well, and we've seen cases too, like one of the ones that came up, it involves some BDSM stuff, and it's the seminal case about unconsciousness and the inability to consent when you're unconscious, called JA. But she actually wanted those charges withdrawn because she said she engaged in consensual activity that she only reported because she was angry and they were splitting up and it was a custody dispute.
Right.
So it was much later that it was reported,
Right.
not at the time. So like just talking about, oh, if nobody goes to the police, well, people can go to the police for different reasons.
At any point in the future.
At any point in the future.
Right. Could be 10 years, 20 years, 30 years later. Who knows why?
And then you're stuck trying to explain, why this behavior was engaged in. And, it's interesting in this case because there was some agreement from the complainant about, what they had agreed to do.
Yeah, so let's talk about that. We're not going to go into huge detail, but it's a very interesting case. And so there's essentially 5 counts. There's an application for particulars just to set out what they were. But, of the sexual assault bodily harm, there was stapling, caning, choking, stapling again and caning, the use of the baseball bat for an insertion, sexual assault with a weapon, which was caning and the insertion of the baseball bat. So various aspects, although flogging and nipple clamping were not part of the actual allegations.
She was, I think, agreeing that was something that
the Crown said that's not part of the allegations. But the position of the parties was good. The defense submits that BDSM practice ought not to fall under the category of activities to which a person cannot consent to bodily harm. This would require a change in the common law. In the alternative, it's argued that the Crown has not proven its case beyond a reasonable doubt for a bunch of reasons. But it was clearly the position that at common law this should change. I think something that Parliament will have to consider because there should be amendments to the definition codes of bodily harm and then what consent can be. But the Crown took the position that clearly they could prove that there was lack of subjective consent to various of these acts. But the Crown also submitted that the charged activities were either not consented to, or consent may have existed but was vitiated through the inequitable power dynamic and or intended cause of bodily harm. The inequitable power dynamic.
I was going to go to the intent.
And in here, the two parties entered into a written contract, which was, a bit inelegant the way it was titled. I don't have it in front of me, but it was Master Whore Agreement, so that, not so elegant. But the Crown tried to argue that there was clearly a power dynamic that then vitiated consent. Have some fun with that one.
Well, there's a big saying, there's a big dispute about who has power, whether it's the dominant person or the submissive person. That's been an ongoing...
Right, and experts will testify to that.
Yeah, because they use the word master, that's why they're trying to say that there was authority. And they didn't get very far there, but the intent, I think, is really important because... Like there's a section here where they talk about the accused. His testimony was very internally consistent. He was straightforward. He was credible. His testimony seemed reliable. And but the thrust of the cross-examination was to highlight his intent on causing bodily harm.
Right.
And to a degree, it was successful. He agreed that he intended to cause pain, and it was the very point of the activities they engaged in. And he testified that bodily harm is the same thing as injury, which he considered, testified that it is the same thing as injury. And so then they get into, different levels of injury and stuff like that. He tried to avoid any serious injuries like gaping wounds. But he was, fairly intent on causing some marks. Like, there was stapling and stuff like that involved. And in fact, they did have to stop at one point because there was some blood and they stopped to deal with the injury.
Right. So let's just talk about this for a second. So it was clear it was very clear that the accused testified very well. But it was very clear that as part of this play, it was intended to cause some form of bodily harm. Okay? Pain and infliction of some injury. But you could argue on the facts of the case that part of this play is some form of bodily harm. Now, he was acquitted on all counts. There was massive reliability and credibility issues with the complainant. I mean massive. And I won't go into the details, but there was a lot, and it came out both in examination in chief and cross-examination. And so that had a major impact. There was the stipulation of what constituted bodily harm, where we had those particulars. So when you didn't have flogging included, the judge was not able to determine when red marks were made, was that because of caning or because of flogging? If it's because of flogging, flogging is not part of that which is charged with, therefore he had to acquit. So I'm not saying that, he sort of, just by virtue of the Crown not including flogging, he escaped it. But I think what's more substantively interesting here is that there is clearly, as part of this play, there's some form of bodily harm. You may conclude that it's not sufficient to reach the threshold, or you could easily conclude on the broad spectrum it would be sufficient to constitute bodily harm. But that said, it's anemic to the actual play, right? So
it's expected. In fact, it's one of the things that the submissive person wants.
Right. So in the normal course, not so much this, it might not be so hard if parties are testifying honestly that part of the idea here was to inflict some level of bodily harm. Nothing overly serious, but something that would heal very easily, like redness would go away in a few days, but that's part of it. And the Crown tried to argue here that no consent could be obtained where the accused induces the complainant to engage in the activity by abusing a position of trust or power, and they would rely on that contract. But there was not enough of the expert evidence itemized here, because you raise a very good point. And I've had a case a long time ago. There was a conspiracy to commit murder where we had an expert from California testify about BDSM play and said the exact same thing. The power dynamic is not what you necessarily think. The power dynamic often is with the submissive, who has safe words and can call an end to the play. So it's not necessarily the person who's supposedly the dominant or the master or whatever you want to call it, is the one with a position of power. And I just want to follow through on this for a moment, because the judge does a very good job of getting rid of this argument that was foisted by the Crown. I don't know if it was terribly well thought out, but and I don't want to be too critical, but I think it's something that we should address. So is that relationship, leaving aside the what would be expert evidence on this, is this type of play creating an abuse of a position of power or of trust or authority? And the judge found that it did not fit into the category of typical relationships where there is an abuse of power or authority or trust. That can be a situation where there's a parent or somebody who's an locus parenti, a teacher, a clergy member, something of that nature. And the judge clearly found here that a person who's a BDSM partner is not in a position of authority or trust as contemplated by that section. And I think there was an argument here for sort of policy reasons that it should be included. But the argument was by the defense that there is neither any precedent nor valid policy reason for expanding the category to include the dominant BDSM sexual partners. And I think that was an important thing to say. Mm-hmm. And that's the law.
Well, this, now, position of authority,
this is good precedent.
Position of authority can get really tricky too, because we've talked about other circumstances where somebody, if they're wealthy or they're famous, right, they're considered to be a person in authority.
They could be. They're not necessarily, but they could be. Yeah,
and it's important because, just because somebody happens to be successful and stuff, they should still be allowed to have whatever partner they want without it being vitiated.
So, to find an abuse of a position of trust, power, authority, these are not closed-ended categories. So you can always leave it open to a specific fact pattern that may describe a situation where there is an abuse of position of trust, power, authority, but this isn't one of them. And it's something that has to be, if you're going to accept this as a legitimate, fun practice that people want to engage in, and they should be allowed to engage in, you cannot include the dominant BDSM partner as in the category where you would have abuse of a position of trust, power, authority. Anyway, so this is precedent now.
One of the points we made off the top, too, is that it is a great case. But one of the points we made off the top is that people who do engage in this behavior, I think, don't realize that it's not necessarily legal. If things were to go the other direction, where you say, well, you can't consent to being caned or something like that, that it's, doesn't matter if they said, yeah, that's something that I enjoy, that you're not allowed to consent to it, then there's a lot of people who are breaking the law who don't even realize it. And that's concerning.
Well, or that they realize that this is either, a gray area, no pun intended, 50 Shades of Gray. It's a gray area. It's, it probably is illegal, but, we're all consenting. We have our own agreements to this. We trust each other. We're in this relationship. It's okay. But this is where I talk about how the state really is involved too much in your sexual activity. There are lines and there are guardrails that have to be up. Where you're wounding or maiming an individual. Well, that's clearly a different category where I don't think the law should change on that fact. And of course, you can run a defense and say, I never intended to do that, and I took steps to make sure it didn't happen. But where there is this play where there's like red marks or a little bit of bruising, I think there is a very compelling case now, based upon expert evidence, based upon the statistics that we have, that there has to be a rethinking of the definition of bodily harm within the context also of particular type of sexual activities.
Yeah. Well, this is a really great case because it covers some of the more extreme behaviors that people think about with BDSM.
Well, there's more extreme.
There is. Yeah, there is.
There is. And again, that case I had a long time ago, that was a well-known conspiracy to commit murder case. I mean, there was a lot of extreme going on in that one, which is clearly illegal, and there's no way that the law is ever going to change on that. But when you talk about caning and flogging and choking, yeah, I mean, an average Canadian might go, how does anybody derive any sexual pleasure from that? This is immoral, and it's bad, and it's sadistic, and we shouldn't allow it. Well, when you look at the stats that both of these experts brought to the table, you're looking at a fairly significant population in Canada and other countries that are either thinking about it or engaging in more milder forms of this, and their activities are inherently illegal.
Mm-hmm. And, just an interesting case that I came across as well, which is fairly recent, has a more mild form of sort of what could be considered BDSM, but it was more just kind of like, kink play or whatever. The accused in that case advanced honest but mistaken belief because there had been an agreement between him and his partner that no means yes is really the phrase that was used. And so they were arguing no means yes. And so when she was saying no, he admits she was saying no, but he didn't take it seriously. And
because that was part of their discussion of advanced play.
Yeah.
Right.
And they came up with like a different word that should be
a code word.
Yeah, like a safe word. And so that they had also talked about mock rape play. And so there's some really
cases? What's the citation for that?
So this case is RVBJ 2025 ABCA 57. So that's Alberta Court of Appeal. So they're looking at it. They upheld the conviction on this case. But so he and his partner had talked about rape fantasy, role play, and stuff like that. And there was an audio recording. There was actually a number of recordings, but they gave an example of the particular one which was not permitted to be used in court, primarily because it was recorded a few years prior to the allegations. But they give the example in which the complainant's saying, I can't say no to you no matter what, because I've already given you permission to do whatever you want, regardless. Especially like it when you me just out of the blue, or whenever you want, especially when you want, especially when it's inopportune, especially when I don't want to. It's the hottest time. The hottest time is when I don't want to, and you want to. To which the accused then says, you like rape? And she replies, yeah, it's pretty hot. So that's part of a recording that he had from discussions as an example of what their agreements were. And
this is not the first time in our podcast we've talked about cases that involve rape fantasy. Right. We're not condoning this, by the way. I mean, it's not like we're saying this is, we're not giving an opinion one way or the other. We're just talking about what the law is out there and what cases are coming up. And this is not such an aberrant thing that this is coming up more and more frequently.
Mm-hmm. And
you have to think about this,
Yeah, and the complainant, was pretty candid in cross-examination about saying, yeah, that's a discussion that we had, but that it didn't apply to these particular instances.
And it may not have.
Mm-hmm. And
This type of play is inherently risky.
Yeah.
Let's just put it that way. It's inherently risky.
And then there was another case that was really funny too, in which they had a code word that was named, and the word red was supposed to be used, sort of like red light kind of thing. And so they gave examples of the instances that the person ended up being convicted of. And so they did engage in BDSM, but they also had non-BDSM sexual activity.
Right.
And so then that was one of the questions, is whether these incidents were actually a BDSM activity where the code word should have been used. And it was found that there was no reason for him to believe that the word stop or no didn't have that effect.
Or didn't have that meaning.
Didn't have that meaning, yeah. But one of the examples of an incident that he gave was that the accused and complainant had discussed a play scenario where he would pretend to be a stranger and sexually assault her. As the scenario unfolded, it took longer. I'm sorry, I'm having trouble not laughing. As the scenario unfolded, it took longer for him to find her. And when he did, then he couldn't get an erection. So then
it was like kind of hide and seek. And it was
like hide and seek, and she was too good.
Yeah.
So their whole scenario didn't play out. But then as they're walking back, he grabbed her and then, I guess, got his erection back, grabbed her and pulled her into a stairwell and had sex with her at that point, at which point she was saying, yeah, she was not okay with that anymore.
Right. So this all goes to show that, again, human beings are complex organisms, and we all have complex psyche, emotions, beliefs, things that interest people. And we have to apply a different lens now when we look at these cases, and not necessarily impose upon it what might be more traditional views that you held 10, 20, 30 years ago. We have to have much more nuance, much more understanding, and much more openness about what is out there so that we can more fairly judge these cases. And some of these are perfect examples that this type of sexual conduct is inherently risky. It's risky. And you have to be really attuned to the partner to make sure that they are truly communicating consent at the time. And that may be very hard with this type of play. So we're not making a policy statement on it. I'm just saying it's time to rethink a lot of this in a much more, modern, sort of open mind and way, because we're seeing these cases.
Giving people the ability to make decisions in their own lifestyle and
still respect people's privacy, bodily integrity, and ensuring that there is consent at the time. But understanding that there are people who want to engage in these things, and we can't necessarily criminalize everything, or we shouldn't continue to criminalize everything.
And like you said earlier too, this expert saying that, everything's totally fine and legal unless they decide to go to the police. That's just not a good...
No, but the expert was absolutely correct in a sense that, well, if they don't go to the police, but that kind of misses the point. The point is that the expert was saying, I don't see this type of play as should be criminalized. I don't see that type of activity. If there's spanking and there's a red mark that takes 2, 3, 4, or 5 days to go away, or 6 days to go away, that's something that should draw the scrutiny of criminal law, because these are two consenting individuals who clearly are within a long-term relationship, who enjoy this type of play, so the criminal law should not be applied to them. It was just sort of a throw-off and a funny thing to say if they don't go to the police, and that people can go and make complaints at any time. But this is why we have to be a bit more accepting and understanding and start to think of this in a different way. And I thought this was a very good case, the Pearson case, and I thought it was very well done by Crown and defense. I thought the defense, Jordan Gold, did a very, very good job. I thought the expert evidence was very interesting. And I commend the judge who did this postscript on it, because I think this is something that not only has to be dealt with by the courts, because although the judge acquitted across the board on this for very sound reasons, the judge could consider this, a court can consider that, but this may be something that our government has to deal with, because we're going to have to work with the definitions and change them.
So that it can be consistent across the board and judges have a bit more guidance.
Judges would have guidance, and we could take into consideration other definitions of sexual assault, of bodily harm within certain play, because that would just give clarity and understanding, and therefore be more inclusive and understanding of other ways that people interact sexually.
Exactly.
I hope I was clear on this. Thank you for listening. Do you want to do Pillow Talk?
Yeah, don't forget to comment, like, subscribe, hit notifications, tell all your friends, and leave comments, especially because we do read them, and we do take suggestions for topics.
Thank you. Have a good night, and always thanks for your watching. Good night.